Hello everyone and welcome to today's Mondac webinar in association with Shihui Partners and an expert panelist who will provide in-depth exploration of arbitration in China and key developments that individuals will need to be aware of. My name is Jordan Wright and I'm joined by a brilliant speaker today to take us through today's discussion. Bao Zhao's practice mainly focuses on dispute resolution and has represented clients before China's International Economic and Trade Arbitration Commission, the Beijing Arbitration Commission, Hong Kong International Arbitration Center, Singapore International Arbitration Center, Stockholm Chamber of Commerce, and the American Arbitration Association. He has also acted as co-counsel in court proceedings in the United States, Hong Kong, Luxembourg, and the Cayman Islands. Mr. Zhao's practice covers a wide range of commercial disputes, including equity repurchases, bankruptcy and liquidation, corporate management, cross-border equity misappropriations, etc. In the area of intellectual property, Mr. Zhao has addressed disputes pertaining to source code infringement, trade secret misappropriation, trademark licenses, technology transfer agreements, and patent development cooperation. But before I hand over to Bao to begin today's webinar, a quick housekeeping item. You can submit questions for the panel by typing them into the question pane of the toolbar on the right-hand side of your page. They will endeavour to answer as many questions as possible during the Q&A session, but please do reach out to them after the webinar for additional information. It is now my pleasure to hand over to Bao to begin. Thank you very much.
Thanks, Jordan. Hi, my name is Bao, and today it is my great honor to be here and share some of my thoughts and my experience in the arbitration systems in China. In recent years, I frequently heard some questions from my friends and my clients outside China about the enforcement of, for example, enforcement of international awards in China, and also some questions like when they do business with Chinese companies, the Chinese company may propose that the contractual disputes to be referred to Chinese arbitration, but they don't know much about arbitration in China. So I think today it is a precious opportunity for me to provide you with a general introduction of the arbitration system in China and show how arbitration works in China. Today, my speech will cover 5 topics, but I have only 1 hour and even less than 1 hour, excluding the Q&A. So it is impossible to go through all these topics in many details, but I will try to focus as much as possible on the important parts for your attention and for your reference. Let's start with the legal framework of arbitration system in China. The legal framework mainly consists of New York Convention, arbitration law, civil procedure law, and as well as the arbitration rules made by the major institutions in China, arbitration institutions in China. So let me elaborate a little bit more. When it comes to international arbitration, like arbitration in ICC or HKC, and then bring it to China for enforcement, then it will be governed by New York Convention, which is automatically applicable in China. But when it comes to Chinese arbitration, it will be governed by domestic law, mainly the arbitration law. And the Chinese arbitration will be further divided into 2 types, depending on whether it involves any foreign-related elements. If there's no other foreign-related elements, like the 2 Chinese companies has contracts and the enforcement of the contracts are all within mainland China, then it will be classified as a purely domestic arbitration. But if there is any foreign-related elements, like it is dispute between a Chinese company and a UK company, let's say, or a dispute between 2 Chinese companies, but the subject matter is the company shares of a Singapore company, for example, or even the subject matter is also within China, but the enforcement of the contract will involve other jurisdictions like Hong Kong or something or some other jurisdictions. They will all be classified as arbitration with foreign-related elements, which is a relatively broad concept. So the purely domestic arbitration will be governed by a regular set of rules, while the arbitration with foreign-related elements will be governed by a special set of rules within the arbitration law and also the civil procedure law of PRC. And I will explain it in more details later. Now I want to have your attention to the fact that we are about to witness an important reform in arbitration law. The existing version of PRC arbitration law was effective from January 2018, but only 3 years after the effective date, the People's Congress released a draft for amendment of the PRC arbitration law. It can prove that how quickly the arbitration system in China developed, because only 3 years after the effective date of a law, the Congress decided to initiate an amendment in order to catch up the latest practical development in arbitration in China. And after this draft for public comments in 2021, 3 years after that, in 2024, an updated draft was submitted for first review of National People's Congress. And then 1 year after that, just in the last month, in the April of this year, a second draft was submitted for second review of National People's Congress. And it can be expected that the draft for the second review will be very close to be finalized and to the final amendment. And once the official amendment was passed, it is passed, I will produce an article to update you with the any development in the arbitration law. So now let's move to the first chapter, the validity of arbitration agreement. Under the existing arbitration law, for an arbitration agreement to be valid in China, 3 conditions must be satisfied. First, the parties must express their intention to arbitrate. Second, the parties must specify the matters to be resolved by arbitration. And third, the party must designate a specific arbitration commission. And these 3 conditions remain to take place even according to the amendment. So I mean, even the draft amendment was approved by the Congress, these 3 conditions will remain to take place. And also, the Chinese courts adopt the doctrines of the probability and competence. They are all adopted and acknowledged by Chinese courts. And then I want to introduce some important rules in regard with the validity of arbitration agreement. Rule number 1: if a contract does not contain any foreign-related factors, the parties cannot submit such dispute to a foreign institutions for arbitration. Otherwise, this arbitration agreement shall be deemed as invalid. For example, there are 2 Chinese companies. They reach a contract, and the contract subject matter and the performance of the contract are all within mainland China. But the parties agree that the dispute shall be submitted for ICC to arbitration for arbitration. And then the dispute arises, and they go to ICC for arbitration. The ICC may accept this case, depending on as long as it complies with its own rules. ICC may accept this case, and also ICC may make a final award on this case. And then parties bring this award back to China for enforcement. They cannot do that because under Chinese law, such an arbitration agreement is invalid because they do not involve any foreign-related elements, so they can only choose PRC arbitration instead of foreign arbitration. But as long as there are any foreign-related elements, not necessarily for France, because ICC stated, for example, they agree that this should be arbitration in France by ICC. So for this agreement, for this arbitration agreement to take effect, it is not necessary that they must have France-related elements. They don't need that, but they must have some foreign-related elements, which means the parties, the subject matter, or the performance of the contract must involve any other jurisdictions other than China. It can be Hong Kong, can be Singapore, can be Japan, whatever they want. Then they can agree to arbitrate by whatever institutions they want with whatever seats they want. But there must be a foreign-related elements other than China. This is a general rule. But there is a very important exception to these rules. If a foreign invested enterprise registered in the free trade pilot zone in China, then it can subject the dispute even without any foreign-related elements. They can submit this dispute to a foreign arbitration institution. I want to explain 2 points here. First, what means foreign invested company? If there is a company registered in China and some of its shares are wholly or partially owned by a UK company, for example, this company will also be classified as Chinese company as long as it is registered under Chinese law. And the only fact that its shares being held by UK company does not mean that there is any foreign related elements. If the opposing party or the contracts does not involve any other jurisdictions, then the only fact that one party's shares being held by a foreign company does not mean that there is any foreign related elements. But if such a company is registered in the free trade pilot zone, then it can have exception. It can submit the dispute to a foreign arbitration institution even if there's no other foreign related elements. And what means free trade pilot zone? There are 22 provinces in China. There are 22 provinces in China that have established free trade pilot zone. Among them, the most popular is, for example, the Shanghai free trade zone, and also Hainan free trade zone, also Shenzhen Qianhai free trade zone. This free trade zone can enjoy some special set of open policy to encourage overseas business. So there are a lot of special set of rules regarding the free trade pilot zone, and there is an exception to these general rules about the arbitration agreement. And rule number 2, the party's intention to submit for arbitration must be clear and definite. Otherwise, the arbitration agreement may be deemed as invalid. That means the litigation or arbitration clause is invalid under Chinese law. You must specify whether to go in litigation or arbitration. If you say we can either go litigation or arbitration, it is invalid until and unless they reach a supplemental agreement on arbitration. And rule number 3, the arbitration institution selected by the parties must be specified and can be identified undisputedly. Which means, for example, the parties agree that we shall have the dispute to be arbitrated in Beijing. This arbitration clause is invalid because in Beijing there are at least 2 institutions. First, the CTEC and also Beijing Arbitration Convention. There are 2 conventions, and it cannot be identified which one do these parties have selected. So it is invalid. But please be aware that if the parties make a wrong name, named a wrong institution, but from an objective perspective, this wrong name can still be interpreted as referring to an existing convention, then such wrong name can be valid. It can be a valid arbitration agreement even with a wrong name. For example, I have handled a case where the parties agree that the dispute shall be settled by arbitration at Singapore Arbitration Convention. There is no such institution, right? But when the opposing party came to Beijing court for litigation, it said that, well, there's no such convention whose name is Singapore Arbitration Convention. So there's no arbitration clause, which means they can solve it by litigation in Beijing. But Beijing court said, although it is a wrong name, but by objective interpretation, a reasonable person would perceive that when naming this Singapore Arbitration Convention, the parties should mean SIAC. So the Beijing court dismissed this litigation, and now this case has moved to SIAC. Also, if the parties agree that we should arbitrate this case in a city in which there is only one arbitration convention, this clause can also be a valid arbitration agreement. In my last example, I said people can say we arbitrate in Beijing. It will be invalid because Beijing has 2 arbitration conventions, at least 2. But if they said we can arbitrate in Hangzhou, where there is only one convention, then it can be valid. So it shows that the Chinese court adopts a pre-arbitration policy, which means even the text of the agreement is not so accurate or not so or even ambiguous. The court will try their best to take an objective interpretation to make this agreement a valid arbitration agreement. So they can support the agreement by this way. So this is the policy that the Chinese court has adopted, which we call pro-arbitration policy. So now let's move to the institutional arbitration in China. Let's start with ad hoc. The China's attitude towards ad hoc arbitration also depending on whether the ad hoc arbitration is an international arbitration or a Chinese arbitration. Ad hoc arbitration. If the applicable law to the arbitration agreement is the law of PRC, ad hoc arbitration is invalid. But if the applicable law to the ad hoc arbitration is foreign law, then the ad hoc arbitration can be valid. And if the parties made an ad hoc arbitration outside China, they can still apply for recognition and enforcement in China. But when it comes to ad hoc arbitration in China, under the current arbitration law, it is not acknowledged. But the draft for second review conditionally opened the door to ad hoc in two types of cases. First is a dispute arising in foreign-related maritime matters. The second exception is a dispute with foreign elements between enterprises registered in the free trade zone approved by State Council. Again, this exception is regarding the free trade zones, which the government has adopted some special set of rules to encourage overseas business. But in general, ad hoc arbitration is not acknowledged in China as a general principle. So most of the arbitration in China shall be institutional arbitration. And here I would like to introduce three major institutions for your selection in future, maybe. The first and most popular one is CITEC, China International Economic and Trading Arbitration Convention, and BAC, Beijing Arbitration Convention, and SCIA, which stands for Shenzhen Court of International Arbitration. These three arbitrations are among the most popular international commercial arbitration center in China. And what is the most remarkable advantage of doing business in China? I think compared with international arbitration proceeding, there are two main advantages to have arbitration conducted in China. First is Chinese arbitration is more simplified and more time efficient. And second, Chinese arbitration is more budget friendly. And let me explain it a little bit more. First, what means simplified proceeding? This is a typical flow chart of an international arbitration in HKC. I use HKC as an example. So this is a typical time flow chart. And this is a typical flow chart of an arbitration at CITEC. So you can see that it is much more simplified, right? And usually an arbitration in China will be finished within 1.5 years, and even 1 year sometimes. And it is much shorter than international commercial arbitration. Let me give you an example. That now I'm doing a case which is very straightforward. The merits of this case is about the equity repurchase. And this case is in SIAC. And this case has lasted for 3 years and it is still ongoing. It is still not finished. And sometimes I complain with my colleagues that if this case was heard in Chinese arbitration like SIAC, I would even have finished the enforcement proceeding already. So I think Chinese arbitration is much more time efficient compared with international commercial arbitration. And also Chinese arbitration is much more budget friendly because the tribunal in China will charge the fee based on the amount in dispute instead of hourly rate. Although in recent years, some tribunals has tried to adjust their fee schedule and try to charge the fees based on the hourly bills, but it is not a common practice. The common practice in China is still that the tribunal will charge depending on the dispute, the amounting dispute. And all these major institutions have a calculation of fees on their website, and it is very convenient. You can just type in the amounting dispute, and then the system will tell you how much they will charge, including administrative fees and the tribunal's fees. So for a company which really need a fixed budget or a manageable budget, I think the Chinese arbitration will be very helpful because the budget will be very clear. And also, it is not as expensive as international commercial arbitration. For example, I will give you an example and let the number to speak. I have another case, which is arising out of a loan agreement, not very difficult. And this case is heard by HKIC. It is not finished yet, but up to date, the tribunal fees has reached over 2 million RMB. And if such case was heard by CTEC, the tribunal fees or the total fees will be about 300,000 RMB. And for BAC, even less. And SCIA, very close to CTEC, accounting for almost 25% of the expenses in HKC. So for this company, which has a tight budget and also they need a fixed budget, I think Chinese arbitration will do them a favor. It will be very helpful. And then I would like to introduce some key features of arbitration rules of Chinese institutions. First, Chinese arbitral tribunal will heavily rely on written evidence instead of witness statement. And in a hearing and in the hearing of Chinese arbitration, it is not very common to see cross-examination of witness. Instead, what the Chinese lawyer will do is to to clarify the written evidence and also comment and challenge the written evidence of the opposing party. But in recent years, I noticed that the Chinese tribunal has been more and more inclined to have the witness appear in the hearing and do cross-examination. And this is a very interesting phenomenon that in recent years, the hearing of Chinese arbitration is more and more close to international commercial arbitration. But in general, we would still rely more on written evidence instead of witness statement. And the second point is the China's arbitral tribunal will be more actively involved in fact-finding process. Unlike international arbitration, where it is the attorney who leads the hearing, and the tribunal will usually ask questions along with the presentation of the attorney. But in Chinese arbitration, it is not the case. The tribunal has, and even either in the Chinese court or in Chinese arbitration, the tribunal or the court have the power to take initiative to investigate the facts of the case. And they can ask whatever questions they want, even beyond the scope of the party's presentation. They can ask any question at any time they want. So they are more active. So the tribunal in China is much more active than the tribunal in international commercial arbitration. And the third point I want to make is that the tribunal in China is largely reluctant to close the door to new evidence. We know that in international commercial arbitration, international commercial arbitration, the tribunal will set the procedure order number 1, and it will set a lot of time limits for submitting factual exhibits. And if you miss these time limits, the door will be closed to new documents or new evidence. But in China, the tribunal is really reluctant to close the door to new evidence. And the parties are even allowed to submit supplemental evidence even after the hearing, as long as the opposing party is given sufficient time to comment and to challenge the supplemental evidence. As long as they have this, the opposing party be given this opportunity, the tribunal will let the evidence in. And in some extreme scenario, for example, the lawyer of one party concealed evidence and submitted evidence in bad faith for surprise attack. Even in this scenario, the tribunal may will make some punishment on the lawyer or on the party. But even in this scenario, they will not exclude the evidence from the record because Chinese court and Chinese tribunal will give a strong preference to the objective fact investigation work. So they will not close any, so they will not exclude any evidence as long as it is relevant to this case. So the cultural difference, the difference in legal culture will always make some confusions and misunderstanding between Chinese lawyers and foreign lawyers. And I think it is it is my pleasure to build a bridge between this cultural gap. So now let's move to another topic about the interim measures in arbitration procedure. That means the enforcement of interim measures by Chinese court in support of an arbitration proceeding. First, let's look at the enforcement of interim measures made by a tribunal in foreign arbitration proceeding, like in ICC tribunal or in CX tribunal. In principle, the interim measures made by a foreign tribunal cannot be enforced in China. But there is an important exception that if the tribunal is at 5 institutions in Hong Kong, including HKIAC, then the claimant can apply for enforcing the interim measures and apply for property preservation in mainland according to the Arrangement for Mutual Assistance, which is passed in 2019. So I think that is a very large advantage of HKIAC because the parties in HKIAC can be entitled to apply for preservation, property preservation against Chinese parties or foreign parties who has assets in mainland China. But when it comes to PRC arbitration proceedings, then the party can apply for preservations or interim measures very smoothly with Chinese court. And let me give a set of number. In the last year, there were more than 5,100 applications for property preservation in support of PRC arbitration proceeding. And among them, 4,900 applications were approved by the court, and almost all of them were finished or completed within 1 month, and that is very efficient. And also, the threshold of this application is not very high. Unlike in Hong Kong or in other jurisdictions where the parties, where the applicants need to prove that there is a realistic risk that the assets will be transferred or otherwise disposed of. But in China, you don't need to prove such so-called realistic risk. All you need to do is to buy an insurance for mistaken preservation, and then you can go to court and apply to a freezing order to freeze the bank account of respondents or other assets like the cars or their real estates or shares, anything you can freeze. You can apply the court to do this property preservation in support of the arbitration. So I think this system, this preservation system, is very smooth and efficient in China. And in the last month, there's a very important development in interim measures. That is the court search order in Shanghai. In this case, the parties to arbitration in Shanghai apply for interim measures. For what? For they apply to have an investigation against the respondent's bank account. And the tribunal approved such interim measures and issued a measure which entitles the claimant to investigate against the bank statement of the respondent. And then the claimant take these interim measures to Shanghai court, and Shanghai court enforced these interim measures by issuing the court search order, directing the bank to produce the bank statement of the respondent. Well, it is a very important development because from this case, the parties to PRC arbitration will be entitled to rely on court search order to search the bank statement or the real estate information or other matters that can be searched by the court. So it will be very helpful in China. So in generally speaking, the Chinese courts, as I said, adopts a pro-arbitration policy in terms of the interim measures and also the property preservation in support of the arbitration. So the last chapter will be the recognition and enforcement of arbitration awards. Again, it will depend on whether the awards is an international award or a Chinese awards, and also whether the Chinese awards involve foreign-related elements. Let's first look at the enforcement of international arbitration awards in China. The application of the enforcement of international awards will be governed by New York Convention, which is automatically applied in China. And the Chinese court has exercised extreme cautiousness to refuse enforcement of international awards. And I can say that it is extremely difficult or even impossible for a Chinese lawyer to apply for a non-enforcement of international commercial arbitration awards. And over the past 20 years, there are less than 10 cases where the court refused to enforce international awards over the past 20 years, less than 10 cases. So you can see how difficult it would be for Chinese lawyers to reject the enforcement of international awards. And in order to guarantee that the Chinese courts will exercise extreme cautiousness towards New York Convention and towards the international arbitration awards, China has established a reporting system, which means first, all the application for enforcement of international awards will be accepted by intermediate people's court. And if the intermediate people's court decided to enforce this award, then it can enforce directly. But if the intermediate people's court decided not to enforce such award, then it must be reported to the High People's Court for approval. If the High People's Court said, no, you should enforce this award, then it's finished and the award shall be enforced. But if the High Court agreed with the Intermediate People's Court that the enforcement should be refused, then it should report it to the Supreme People's Court. Only when the Supreme People's Court agreed that this enforcement should be rejected would this award be rejected for enforcement. And if any of these three courts said you should be enforced, then the award will be enforced. So it can prove that the Chinese court has, in order to guarantee that the international awards will be smoothly enforced in China, they have not only adopt the grounds on the New York Convention very cautiously and restrictively, and also they applied a reporting system to guarantee that any decision to refuse enforcement of international awards will be checked step by step until the Supreme People's Court. So you can see how cautious Chinese court is toward the international commercial arbitration. And then let's look at the enforcement of Chinese arbitration awards with foreign-related elements. That is not governed by New York Convention, but it is governed by a special set of rules under arbitration law. But you can see that the grounds for non-enforcement of arbitration awards with foreign-related elements, the grounds are as restrictive as New York Convention, although the wording is slightly different. But Chinese court will still apply these grounds very restrictively in order to enforce the foreign-related awards as smooth as possible. And again, the reporting system is same as international arbitration. That means for an award with foreign-related elements to be refused for enforcement, it must report it step by step to the Supreme People's Court to final review and final approval. That is the same as international commercial arbitration. And Finally, that is the enforcement of Chinese domestic arbitration awards. The grounds for non-enforcement of the domestic arbitration awards are a little bit broader than UN Convention and also the special set of rules towards foreign-related awards. Under the regular set of rules, the court will be entitled to look at the evidence sides of the based on which the award was made. And if the evidence is fabricated or the parties concealed evidence that may influence the fairness of a word, in these scenarios, the court are entitled to refuse enforcement of a purely domestic awards, but these grounds are not in place regarding the international awards or foreign-related awards. And also, the reporting system for domestic awards are a little bit different. There are two types. First, if the domestic awards are rejected for arbitration based on public policy, then it should be reported to Supreme Court in order to guarantee that the local court cannot abuse the application of public policy. The interpretation of public policy must be unified and consistent among the entire country. So if you want to refuse the enforcement based on public policy, such decision will be reviewed by the Supreme Court. But if a purely domestic awards are refused to enforcement on other grounds, then such decision do not need to be reviewed by Supreme Court, and the High Court approval will be enough. So we can see that China has adopted three systems according to international arbitration and arbitration with foreign elements and domestic arbitration. And that is extremely difficult to challenge awards in international arbitration and also a foreign-related arbitration. And that shows what I always said, the pro-arbitration policies, which is in line with the country's opening policy. Yes, and I think I should, because I still need to leave some time for Q&A, it would be better to stop here. As I said, it's just a very brief introduction, and I do hope that in future I will have a further opportunities to go deeper on the particular topics that you may be interested. So I will close my presentation here, and I'm look forward to discussing more in the Q&A stage. Thank you.
Fantastic. Thank you very much, Bao. We've just got a couple of questions here. So first of all, in a commercial agreement involving a China state-owned entity, would the existence of a waiver of sovereign immunity clause in the contract be sufficient to, one, initiate arbitration against state-owned entity in China, and two, to initiate proceedings before a court in China for the enforcement of an arbitral award against the state-owned entity in China?
Well, I don't think there is any difficulties in enforcing the awards against the state-owned companies. First of all, if there's a commercial arbitration, even if the respondent is a company directly owned by the government, there is no sovereignty protection to these state-owned companies. In a commercial arbitration, there's no such sovereignty. And I think it will be even more convenient and even more feasible to enforce against state-owned companies than a private company in China. Because in China, we will do a credit system, which can show that if you type the name of a company in this system, the system will tell you that how much litigation this company is going through and how much judgment it has not been paid, it has not been performed. And this is very important system in China. And in my experience, the state-owned companies will be very afraid of being listed in such credit system. So when there's a judgment against a state-owned company or enforcement or award against state-owned companies, usually the company will perform it, voluntarily perform the award instead of being performed, instead of being enforced against. And if you successfully apply for enforcement from against a state-owned company in a Chinese court, again the company will usually pay the debt. Yeah.
Fantastic. Thank you very much. I've got a couple more questions here. So, if a foreign entity is going to enforce an international award against a PRC state-owned company, would there be any difficulties in enforcing such an award in China?
No. Sorry, can you ask me it again?
Yes, so if a foreign entity is going to enforce an international award against a PRC state-owned company, would there be any difficulties in enforcing such an award in China?
Well, I think I have I think I have answered this question. No, there's no any difficulties enforcing against state-owned companies in China.
Okay, great. So, and what kind of methods would the PRC courts take in enforcing an award?
Well, usually the court will take initiative to investigate the assets. So the company, the court will freeze all the bank accounts of the respondent, and also only real estate or shares or any cash they owned. You do not need to provide any asset clues to the court, and the courts will actively do such investigation. And then the court will transfer the bank transfer the money from the responsive bank account to the claimant, and also they will cite the shares and also attach the real estate for sale in order to enforce these awards. And if after all these efforts there's still outstanding payment, then the court will list the respondent and also also its legal representative to the credit system to show that these companies still owe the judgment, and that will be a very serious signal to this company. Yeah.
Great. And are foreign lawyers entitled to attend as counsel in Chinese arbitration proceedings?
No, no. It's unlike international commercial arbitration where Chinese lawyer can attend an HKIC arbitration as counsel. But in China, only Chinese lawyer or only Chinese licensed lawyer can attend a hearing. But the foreign lawyer can attend the hearing in China as an observer, or yeah, they can attend, but not in the capacity of a counsel.
Great. And then we've finally got one last question. So, is it true that in each region of China, one should hire a local lawyer in that region to handle their enforcement case?
Oh, no, 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 because China is not a federal country. We are a united country. So um, there is there's no bar in each province, which means I am a Beijing licensed lawyer. I can practice law in any of the province, the cities in China. So you do not need to hire a local. Like if you have a judgment against the respondent in Shanghai, you can hire Beijing lawyers or Shenzhen lawyers, whatever lawyers you want in China to enforce such, to engage in this proceeding.
Fantastic. We've got a couple more questions that just come in now as well. So, being party to the New York Convention, why does China have strong state immunity against foreign arbitration for domestic parties?
So let's see it. Why does China have strong state immunity against foreign arbitration for domestic? Sorry, I do not really understand this question. So,
Okay, no problem. We can move on. So, which arbitration institution in China is more frequently used for arbitration with foreign element?
I think that is CTEC and SCIA. I will give you an introduction about the three institutions like CTEC, BAC, and SCIA. I think CTEC is the most popular and most influential one in China, and the panel of CTEC is the most comprehensive, and you can find whatever expertise you want, like the UK law, Singapore law, or even Russian law. So some companies, some foreign companies will choose CTEC because they can always find the arbitrator they want in the panel. But in recent years, I think this SCIA, which means Shenzhen Court of International Arbitration, has developed very quickly. The most advantage of SCIA is that it has adopted it has adopted a lot of high technology equipment, and also like the cloud storage, and also the survey system is very well developed. So it depends on what the parties look for. If they look for the panel, then they will go to CTEC. But if they want to have a better experience in doing arbitration, I think now many parties choose SCIA.
Great. A couple more questions here. So, which one would prevail if there is a conflict between an arbitral award on the one hand and a separate China court judgment or an interim order by a Chinese court on the other hand?
Well, it's a really good question. It's a really good question. I think it is not very common to see in practice, because if the same subject matter is heard by the Chinese court, the opposing party will say you need to dismiss this litigation because we have arbitration clause. So I don't think it's very common to see in practice. But if it does happen, according to my question, I think the arbitral award will prevail, in the sense that if one party wants to set aside the award, they must say that it is violate the public policy of China. And it is not the case that it is not strong enough to argue that because the Chinese court has another judgment on the same subject matter, so this is a public policy, and you must set aside the award because of the violation of public policy. Being different with Chinese judgment does not mean the violation of Chinese public policy, because Chinese court will interpret public policy very, very cautiously and restrictively. This is my answer.
Great. We've got a couple more questions here relating to competence. So does the PRC court recognize the doctrine of competence? And is the negative competence really recognized again by the, so is it recognized?
Well, I think it's a very good question. And the rules in China is that the arbitration convention has the power to, under the existing law, the arbitration convention, not the tribunal, but it is the arbitration convention who has the power to rule on its own jurisdiction. The party can choose either to go to convention for the jurisdictional challenge or go to court. And if they choose both ways, then the court it should be the court to decide on the jurisdiction, and the convention should cease to hear the jurisdictional challenge, and they should go to the court. But the convention has the power. In absence of a parallel court proceeding, the convention does have the power to rule on its jurisdiction. But there would be a very important amendment, proposed amendment. It is not officially approved, but according to the draft amendment, the latest draft amendment, the tribunal will also have the power to rule on its own jurisdiction. So now there are three entities have the power to rule on the jurisdiction: the judge, the court, the convention, and the tribunal. If the jurisdictional challenge is submitted after the constitution of tribunal, then the tribunal will have the power to rule on its own jurisdiction. But again, if the court has already accepted this jurisdictional challenge, then the tribunal should defer to the court for the final decision. And this is my answer.
Fantastic, thank you. And on account of the neutrality perspective, if both parties in China chose the foreign seat, shall the award be recognized and enforced?
Let me see it. If both the parties in China choose foreign seat, shall it be? Well, no. First of all, Under the current arbitration law, there is no such concept as arbitral seat. It's very surprising, but I must say it. I must commit it that under the current arbitration law, there's no concept of arbitral seat. But this concept will be observed into the system by the amendment, and both the 22 amendment, both the 2021 draft, 24 draft, and the 25 draft, they all remain to establish the concept of arbitral seat. So maybe in the next year, China will adopt the arbitral seat. But even in that time, I don't think that if there is no foreign related elements, two parties in China can decide the seat to be a foreign seat. Because if the seat is a foreign seat, then it will be protected by New York Convention. But as I said, in the general rule, if there is no foreign related elements, they cannot submit to a foreign arbitration or choose a foreign seat. But again, I think there is one exception, that if there is a foreign invested company registered in the free trade zone in China, then they can choose a foreign seat. That is my answer.
Fantastic. Another question relating to competence. So what are the elements of negative doctrine of competence in the arbitration law of China?
Well, this is a very good question, and I think there is judicial interpretation very newly adopted in this point. And if you don't mind, would I do a further research and answer this question by email? Okay.
Absolutely.
Yes, because it's the very latest, because it's newly developed rules on this topic. Yeah.
Fantastic. And then finally, does the CIE-TEC have a branch in Shanghai?
Yes, CTEC has branch in Shanghai, in Hong Kong, and I think the Shanghai has two important arbitration center. First is SHIAC, Shanghai International Arbitration Center, which is also very popular, at least in recent years. And another is CTEC Shanghai branch. They are both very popular. Yeah.
Fantastic. And finally, is doctrine of separality recognized?
Yes, definitely. If the entire contract to be hold invalid or even non-existent or be set aside, the arbitration clause will remain.
Great. So I think that is all of our questions today. Bao, do you have any closing thoughts, any final thoughts at all for our attendees?
No. I think all these questions are valuable, and I'm happy to sit here and to discuss with this great audience. And in future, if you have further questions, you can have my email, I think. Yes. I will share my email with you, and any questions at any time you can email me, and I will answer in my best.
Fantastic. Well, thank you so much for taking the time with us today. Thank you all to our audience for joining us on the behalf of everyone at Mondac, and we look forward to welcoming you back again soon. So many thanks, and hope you all have a good day.